Okay, members, next up, the last omnibus bill of the evening is, was Senate File 803. Representative Cornish, if you will come forward. Okay, so, yeah, members, first of all, I need to move Senate File 803 and then move to substitute the language of House File 896. And members, this is just a procedural motion. Any discussion? Seeing none, all in favor signify by saying aye. Aye. Opposed? Motion prevails. The motion is adopted. The amendment is adopted. Okay, Representative Cornish, why don't you go ahead and present your bill, and then we'll take the amendments.
Okay, Mr. Chair and members, thank you for saving the best to last. We, House File 896, as you know, funds the Bureau of Criminal Apprehension Corrections, the judiciary, a number of programs that go into the OJP. Why don't I give you a flyover of the spending highlights, and then I have my experts here in policy and finance that can back me up for any questions you want to go through spreadsheet or line by line, however deep you want to dig. But I'll give you the how we spent $2.2 billion bucks. The $52,765,000 across the judicial branch and agencies for the 1% compensation increased health insurance costs. $20 million for increased inmate care costs for the Department of Corrections. $15 million for the additional reimbursements to local law enforcement agencies for costs of training. That entails the police training bill that you've heard about. The $5.7 million for enhanced sentences of supervision of sex offenders. $4.1 million to replace the predatory offender registry at BCA. $3.2 million for upgraded technology system to allow all peace officers to access and serve the harassment restraining orders. A little over $2 million for, for Red Wing DOC, the Rape Prevention Act, compliance. $2 million to replenish the disaster assistance account. $1.7 million for 2 new judge units. $1.5 million for expanded mental health services at DOC. $500,000 to extend grants to combat terrorism recruitment. $479,000 for additional sex trafficking prevention grants. It would be not named for the jurisdiction, but would be a competitive grant through the OJP, Office of Justice Programs. $208,000 for the administrative costs of the appraisal for the Appleton Prison to lease to own or purchase. $200,000 for crisis de-escalation training of public safety personnel. That's the one that we've done before, I think Officer O'Driscoll's. $200,000 to Representative O'Driscoll. $200,000 to support treatment courts, specialty courts. $200,000 for targeted domestic violence prevention and program at DOC. $170,000 for alternatives to incarceration treatment for certain nonviolent substance abuse offenders who violate terms of probation, and $150,000 for nonprofit security grants. Had a number of policy bills and bills that carried fiscal costs. I think we have 4 or 5 also from the DFL. And that's for the spending highlights. And that's basically the spending on the bill, Mr. Chair and members. If you would like to know separate policy issues or details, I'll sit for questions.
Okay, thank you, Chair Cornish. Well, members, let's go to some of the amendments first. Representative Davids, I know, has an amendment. Representative Davids moves the A17-0329 amendment. Representative Davids, could you speak to that amendment?
Thank you, Mr. Chairman. I'd like to thank Representative Cornish for allowing me to present this amendment on this bill in Ways and Means. Several years ago, a bill was passed that basically said, and it was overwhelmingly passed in the House. I think it had over 120 votes, and the governor signed the bill. Might have been unanimous in the Senate. Passed overwhelmingly that said that if a not-for-profit or a charity gets a donation, takes it in good faith, that they cannot have it clawed back if later on it was found that the person that made the donation was a crook. And what was happening was, because that bill was passed overwhelmingly and signed into law by the governor, many not-for-profits and many charities were able to stay in business, because what was happening, there was a law firm that was very good at clawing back on gifts that were made previously, unbeknownst to the charity that there was a problem. So the bill said that if the charity knew that, did not know that the gift was given by someone who was of nefarious activities, that they did not have to pay that back, and there's some time limits and so forth. Apparently, there was a judge that was unable to read the law and interpret it, and basically said that it was simply for cash donations, which was never, ever the intent of the legislation. So what this amendment does, it clears up that it also covers other types of donations, not just cash. So just to look at it a little closer here, the purpose of this amendment is to clarify that the law applies to all kinds of gifts, not just cash. Nonprofits often receive gifts of stocks, bonds, notes, and other kinds of property. The bankruptcy court has been interpreting the law to only cover gifts of cash from the debtor, which was never the intent of the law. We're simply seeking clarification consistent with the original intent of the law. Mr. Chairman, I'd move this amendment and stand for questions.
All right, Davids moves the A17-0329 amendment. Representative Hillstrom.
Thank you, Mr. Chair. If Representative Davids could answer a couple of questions about the proposal. One question is, if they find out that the person who filed bankruptcy kind of knew they were in trouble, knew they were getting ready for bankruptcy, and made a whole bunch of contributions to the charity, kind of to get around some of the bankruptcy laws. You know, we had a car dealer who was doing all sorts of things with their automobiles. We had another business that we now see those folks in federal prison. My question is there any limits if this person is, you know, right on the verge of bankruptcy and then giving those items?
Could you speak into the microphone more directly, Representative Hillstrom?
Thank you, Mr. Chair. So Representative Davids, in the event that the person is right before going into bankruptcy, begins giving away large numbers of pieces of property, is there a time limit by which the bankruptcy court could quickly go back in and get some of those pieces back, or does it not matter?
Representative Davids.
Thank you, Representative Hillstrom. Yes, it does matter. There are some provisions, and Mr. Chairman, I do have someone that could more directly answer that question. I do know we put provisions in where there were some time limits and so forth, so that exact situation Representative Hillstrom is explaining would not happen. I do have some folks that could answer that more directly.
Okay. Representative Hillstrom, should I have a witness come forward?
No, Mr. Chair, as long as those protections are in there to keep someone from doing that, quickly giving away their property prior to filing bankruptcy, I don't have a concern.
All right.
Well, Mr. Chairman,
Representative Davids.
we might want to have somebody just clarify that, because when I remember the bill from some years ago that was supported by many people around this table, there were some provisions, but I would like that explained just a little bit better for the record, so I'm
Okay.
speaking
Could
correctly.
we have a witness come forward on that subject if they're here? Welcome to the committee, sir. Could you state your name for the record and give us your testimony?
Yes, my name is Grover Sayer. I'm a member of a foundation board that has received gifts in the past. And my testimony would be this, that the law as it's currently written, if a gift was received within 2 years, that gift can be possibly clawed back. So that's your protection. Representative, I can't see your name, but that would be the protection.
That's fine.
And that's currently in the law.
Representative? Yes, we're fine.
Oh, yes, I'd appreciate your support.
Representative Carlson?
Yeah, Mr. Chairman, I was going to ask the chair, but maybe I'll ask Representative Davids. There has been times in this committee where some members have raised questions about Ways and Means dealing with policy. I've had less trouble with us dealing with policy than some members have. But Representative Davids, is this policy or not? And I am not going to be against it because it is, because I think sometimes it goes hand in hand. But I think it's a good example of maybe clarifying as we move forward. I don't want to identify who the member was that was raising questions about policy, but probably some members of the committee know who it was.
Representative Davids?
Any response, I guess, Mr.
Oh,
Chairman?
certainly, this is strictly policy.
And I assume, Mr. Chairman, then, that the mover of the amendment has no problem with our dealing with policy in this committee.
Well, Mr. Chairman, I really do unless it's my amendment.
That's what I thought, Mr. Chairman.
Representative Liebling.
Thank you, Mr. Chair. And Representative Davis, I remember when you moved this legislation originally, and I know it had to do with a particular situation and a lot of, I recall some of the original background to this. Maybe you said this, but I didn't catch it. The court case where this interpretation was made that you're trying to undo, was that a district court or was that an appellate court or even the Supreme Court?
Representative Davids.
Thank you, Mr. Chairman. I do not know, but maybe our witness could explain that.
Yes.
To the testifier.
Mr. Chair, Representative, it was a federal bankruptcy court where this decision was made. And essentially, the court is interpreting the statute very narrowly to only include gifts of cash. And often nonprofits receive stocks, bonds, notes, all kinds of things. And so that's the purpose of the amendment, is simply to clarify that the intent was to include all sorts of gifts that might come to a charity or a nonprofit.
So-
Representative Liebling.
Thank you, Mr. Chair. And so, yeah, this is, I think there might be a little more to this than perhaps it's easy to deal with in this context, just as an amendment. Because I'm kind of reading between the lines here. I can only imagine, I usually assume that courts do make these kind of rulings that might be, some people might feel that it's a bit, they're kind of reaching to get to a result. And reading between the lines here, I wonder if that isn't it, because remember, at the same time that Representative Davids is interested in protecting the innocent charity, on the other side of this, we have people who were defrauded, whose money this would otherwise be. So I think that those are the two interests that are kind of facing off here, if I'm understanding the situation correctly. And so, to me, it wouldn't be absolutely obvious that the intent was that it be all property, because a charity, obviously, if it was given cash and it is going to be using that cash immediately, would be in a really different position than if it was, say, some other kind of asset that might be a long-term asset. So I'm not so sure that this is actually the right thing to do. I appreciate that Representative Davids wants to protect charities, and I think we all would, but I think we might also have an interest in protecting people who were defrauded, whose property this would otherwise be, because I think that is the trade-off that's being made here. And maybe the testifier, who obviously will know much more about this than I do, could respond to that, because I didn't come in here prepared to debate this. I just want to really understand what we're doing here, given that we are talking about, I think, people who were defrauded.
Mr. Sayer.
Yes, Mr. Chairman, Representative. Gifts that come to charities are typically liquidated and then donated for the purpose of the charity. And so ultimately they become cash. It is not typically the purpose of a nonprofit or a charity to hold money for investment for long periods of time and anticipate gains and that sort of thing. And so in most situations, the charity will receive a gift and then use it for its purposes And if that gift is then later clawed back, that charity no longer has the money. And so what you're actually creating is another set of victims. And those victims are those that have donated to the charity subsequent to the date of the gift, whose gifts are now being used to pay a fraudster. And so it's a very difficult situation. There are folks that suffer all around the room whenever there's a fraud that's involved.
So, Mr. Chair.
Representative Liebling.
Thank you. And if I could just ask the witness, though, but can you kind of lay out the other side here, though? And I know I hear you, and I think those are serious concerns. I really do. But am I correct that the other side of this lawsuit would be people who were defrauded, who are saying, wait a minute, that was my property, I want it back? Am I right? So, I mean, as you say, we're creating more victims, but there are already victims.
Mr.
Well-
Sayer.
Yes, Mr. Chair, Representative. It's one of these situations where, yes, it's hard, the funds are gone, so we can't make everyone whole. It's impossible. So how far down the road, and how many more victims do you want to create? I mean, that's the crux of the matter. And some of the protection that's in the law, if the charity or the nonprofit knew or had reason to know that the money was created or generated through a fraud, then it's subject to being clawed back. So we're talking about a charity that has no knowledge, simply received a gift, and now is being asked, perhaps many years later, to return those funds which it no longer has. And so we're simply asking for protection for that, but also the court in its opinions has said that the original legislation was confusing. So we're trying to clarify that confusion.
So,
Representative Liebling.
thank you, Mr. Chair. And I appreciate that obviously that this situation only occurs where the charity is innocent too. I get that. If the charity knew, anybody who has an idea they're getting tainted money is supposed to not take the money. We know that. But I guess what I would just say to this, Mr. Chair and members, is that it seems like that the way to handle the situation would be to draw a distinction that is a little different than what form the money comes in. It would seem like the more fair thing would be to draw some kind of a distinction about whether the charity, in fact, doesn't have money anymore, whether it was an asset that's essentially gone, or whether it's something that could actually be recovered. I mean, I don't know what that distinction would be, but I'm not really sure that the way this is structured is really the right thing. I'm not sure we're here tonight in a really good position to evaluate this fully. I just want to say that I don't think it's as clear-cut as all that, and I really do have some concerns about it, because the people who would be on the other side of this are not here to advocate for themselves. Thank you.
Representative Carlson.
Mr. Chairman, is the name Sayer?
Yes.
Mr. Sayer, you said that the property is typically disposed of or converted, but typically doesn't mean all property. And I was sitting here trying to distinguish. I was on the board of a charity that received, they started an auto repair program, and they received as a charitable donation virtually all the equipment that you would need for a fairly sophisticated auto repair program. Now, there was never any question about an illegal donation, but that would be an example, though, of a charity keeping property for a purpose that I'm no longer on the board and haven't been for a few years, but they probably still have the equipment there years later. So is there a distinction under this amendment or under the case law if the charity still has the property in their possession and hasn't converted it to cash for the operation or whatever the charity happens to do for their work?
Mr. Sayer.
Yes, Mr. Chair, Representative. I do not believe that distinction exists in the law the way it's written. But the amendment is, the purpose of the amendment is to simply clarify that the intent of the original law was to include things other than just cash, like bonds, stocks, and other things, which typically come to charities and come to nonprofits. Appreciated stock, for instance, comes to a nonprofit. Then the nonprofit sells that stock and uses the proceeds for its mission. That's typically what happens. Your auto example is sort of the exception to the rule, I think.
Well, Mr. Chairman,
Representative Carlson.
if I sat here for a while, in fact, even just during the brief conversation, I thought of some other situations where land has been donated for various purposes and is held by a charitable group. I'm just thinking that as this moves forward, if the property were still in the possession of the charity, that perhaps there should be a distinction in the law between what is, and I understand what you're trying to say, if the dollars or the property has been converted and is used for program and what have you and has been expended. That would create a problem, as Representative Liebling has pointed out, really on both sides, the charity and the individuals that were perhaps swindled or whatever the situation might be. But there are some instances where there could be some real property that's being held by the charity, land donated for a given purpose. It didn't come about, but I know of a foundation that was offered a fairly attractive piece of land to build a hockey rink on. That never materialized, but had there been some history, you know, that would have still been being held. So I'm just thinking that if this moves forward, perhaps there should be a distinction between property that is still held and that being available for the clawback as opposed to property that has been expended. And if I thought some more, I could come up with even a few more examples of where, because sometimes charities receive something for a specific purpose and they hold it for that purpose. There's maybe even an agreement to use it as a park or something, you know, that's what I'm saying. Maybe the author of the amendment might think about some of that if it moves forward.
Representative Hausman.
Thank you, Mr. Chair. As I listen to this, it feels as though maybe the amendment's misplaced and it should have been in civil law and not public safety. Maybe that's part of the struggle we're having here, that it's not a good fit in this particular bill, maybe.
Any other discussion? Hearing none. All in favor of the A17, aye? Aye. Opposed?
No.
Carries.
Okay, members, next we have some other amendments. The first amendment is, I think, a technical amendment. Representative Cornish moves the A11 amendment. Representative Cornish.
Yes, Mr. Chairman, member, the A11 amendment is a technical amendment. It has to do with a number of ERT teams, and we added one, and so we changed it from 3 to 4 on page 4, line 34. Delete 3 and insert 4.
Any discussion of the A11 amendment? Representative Hillstrom.
Thank you, Mr. Chair. I just encourage members to vote.
All right. This other discussion? Seeing none, all in favor of the A11 amendment, say aye.
Aye.
Aye. Opposed? Motion prevails. The A11 amendment is adopted. Okay, members, next is the A13 amendment. The chair will move the A13 amendment. And members, the A13 amendment is a technical amendment, but it's a technical amendment about a controversial item. And this relates to the language in the bill on page 69 regarding protesters and freeways. And it further defines the word freeway, and it basically does that by simply saying right now the definition of a freeway is a divided highway that has only access and egress points from entrance and exit ramps. But the question is that you've got some freeways like Highway 10 leaving the Twin Cities that start out that way as a freeway, but later on become something else. And so if there was an action under the law, is Highway 10 a freeway depending on where it is? And so the language simply makes it more clear that it's defined as a freeway in between those ramps. So someone can't say, well, even though you might have been blocking the freeway just in the Twin Cities, the fact that it doesn't have exit and entrance ramps up by St. Cloud means that you can't not be prosecuted for it. So members, that's the amendment. It just further clarifies that a little bit. Is there any discussion of the A13 amendment? Representative Hillstrom.
Thank you, Mr. Chair. So I just want to clarify that this is actually narrowing what sections can be prosecuted, because it's only the portions that have exits and entrance ramps. So it would only be the portion that has the exits and entrance ramps, for example, on Highway 10, not the portions that have stoplights.
Well, and the portions in between the exit and entrance ramps. But yes, if you get up to St. Cloud, you couldn't be stopped because it's not a freeway as defined here when it gets up Highway 10, for example, by St. Cloud. Further discussion of the A13 amendment? See no discussion. All in favor of the A13 amendment, say aye.
Aye.
Aye. Opposed? Motion prevails. The A13 amendment is adopted. Okay, members, there are a couple of other amendments. I think they're Representative Hillstrom's amendments.
They are, Mr.
Representative Hillstrom, which one do you want to take first?
Thank you, Mr. Chair. I will take the A1 amendment first.
Okay, the A1 amendment. Representative Hillstrom moves the A1 amendment. Representative Hillstrom, can you define or describe the amendment?
Certainly. Thank you, Mr. Chair. So members, in this bill, it repeals a statute, a law that's been on the books for a very long time. In the event that someone is involved in a crash, and they are the victim in that case, and the court is considering who's responsible and how much that the person who's responsible should pay. Currently, the jury is not permitted to hear whether the person who is injured, if they were wearing their seatbelt or not. We know that there have been many instances, and Mr. Chair, I have a handout that I could pass out about a crash that happened in your area, actually, in the St. Cloud, where a large truck driver ran into a motor vehicle, injuring or killing folks that were inside. Members, the provision that's in the bill would say that the jury could consider whether or not the people who died were wearing their seatbelt in determining how much the insurance company should pay. We don't allow juries to hear whether or not the truck driver had insurance, and this would undo a law that says that the jury shouldn't hear whether or not the victim was wearing their seatbelt. Basically, it's a seatbelt gag rule that is being undone. Members, if you're hit by a drunk driver, whether or not you were wearing a seatbelt, if you did nothing wrong, should not influence how much money you received. You were injured, and it was of no fault of your own. If you adopt the provision that's in this bill, what you're doing is making it so insurance companies will pay less, more cases will go to court and not settle. And I know that to be true because the fiscal note says it costs an entire judge in order to have this provision in the bill. So I delete the section that undoes the gag rule, and I allow the court to keep the judge that they have asked for. Members, our judiciary has said that they are 2 judges short. This would allow them to keep both of those judges and not overburden the judiciary with another amount of court cases that I don't believe result in a just result. It simply is a windfall for insurance companies. And so I would ask members to support the removal of that language.
Okay, discussion of the A1 amendment. Representative Cornish.
Well, Mr. Chair and members, it's Representative Hillstrom's opinion that it should not be allowed. I believe that it should. It doesn't weight the case. It just allows something to be entered that isn't currently allowed to be entered in consideration of the damages. And this bill came through with merit through our committee, and on here I would be disappointed to take a bill completely out of one of our members. It's progress through the committees. It is controversial, but I think it would merit bringing to the floor for more discussion and an amendment at that time instead of taking it out here. So.
Other discussion to the amendment? All right, all in favor of the amendment signify by saying aye.
Aye.
Opposed, nay. Nay. The motion does not prevail. The A1 amendment is not adopted. Representative Hillstrom.
Thank you, Mr. Chair. Mr. Chair, I have the A10 amendment, and this amendment I would ask for a roll call on. Mr. Chair, currently, the Department of Corrections has made it very, very clear that they are not in need of the Appleton Prison. The Appleton Prison is a 1,600-bed facility. There's language in this bill that would require $200,000 be spent to find out what the value of that prison would be. And then there's language that says that in the event the commissioner needs any additional beds, they must either contract to run the prison, leasing it from Appleton or the private company, or they must purchase it. Members, anytime you put in a law that says you must purchase something, the price of that piece of property goes up. And in order to operate this facility, it would cost $52 million a biennium. $52 million in addition to the language that you have currently in this bill and the amount of money that you spend. It isn't something that the Department of Corrections says they need. It is something that they oppose. And this bill would delete the requirement of the acquisition of the Appleton prison. It would delete the money, and it would actually ban the use of private prisons in the state of Minnesota.
Okay, discussion to the A10 amendment. Representative Cornish.
Well, this has been talked about ad nauseum for some time, and I hate to tell a unit of government in Appleton what they can and can't do with their prison and put a never on there. And I think this fiscal note was dreamed up by people that didn't like the idea of the prison and wanted their own prison to take care of it, and the commissioner, or the Department of Correction has been very biased against this prison. We've got a state-of-the-art facility out there waiting to be used if it's needed be, and I just don't believe that this is a proper amendment to just exclude that from the possibility. And we have no idea in our bill that's written to it, the lease to own and staffed by DOC if we would lease it or own it, and so I think this is an unreasonable amendment.
Other discussion to the A10 amendment? All right, the clerk will take the roll on the A10 amendment.
Representative Vogel,
No.
Representative Carlson,
Aye.
Representative Anderson. No. Representative Baker.
No.
Representative Cornish,
No.
Representative Davids, Representative Dean, Representative Detmer. No. Representative Dreskowski.
No.
Representative Fabian.
No.
Representative Garofalo.
No.
Representative Gunther.
No.
Representative Hamilton.
Yes.
Representative Hausman.
Yes.
Representative Hillstrom.
Yes.
Representative Hornstein.
Yes.
Representative Liebling.
Yes.
Representative Loon.
No.
Representative Knobloch.
Aye.
Representative Marquardt.
Yes.
Representative Murphy.
Yes.
Representative Nornis.
No.
Representative Pulowski.
Yes.
Representative Poppy.
Yes.
Representative Torkelson.
No.
Representative Erdahl.
No.
Representative Wagenius.
Yes.
Oh.
There being 12 ayes and 13 nays, the amendment is not adopted. Representative Cornish, members, discussion to the bill as amended. Discussion to the bill. Representative Hillstrom.
Thank you, Mr. Chair. Mr. Chair, given the target that Representative Cornish was given, which I wish had been higher. Representative Cornish did his best to fund the items in this bill that go a long way to protecting public safety. But, Mr. Chair and members, there is a provision in the state government finance bill that negatively impacts this bill, that will also negatively impact others. We heard from the tax court that they needed to do a case management system, and with the target Representative Cornish had, he was not able to fund it. However, in the state government finance bill, it says that in the event that there's a savings from open positions, that they cannot use that savings for any other purpose other than to fill the positions. So we, between the two bills, are placing our judicial system, and in particular the tax court, in a situation where they can't fund the very system that they need to operate, and they can't even fill it by capturing savings by vacant positions because of the language that's in the state government finance bill. So hopefully between now and the end of this session, this bill will only get better and actually allow us to have public safety addressed, because it is a core function of government. So I look forward to working with Representative Cornish between now and the time that this bill will maybe get signed.
Other discussion of the bill? Representative Cornish, any closing comments?
No, Mr. Chair, member, just thank you for your time and wish for your support and vote.
All right, with that, members, Representative Cornish renews his motion that House File 896 Senate File 803 as amended be referred to the General Register. All in favor say aye. Aye. Opposed?
No.
Motion prevails. Senate File 803 as amended is referred to the General Register.